Today, today we'll be discussing class legislation and doctrine of reasonable classification. All right. So actually, what happens that Article 14 it forbids class legislation and it does not forbid reasonable classification. Now you need to remember one thing: it forbids class legislation. However, it does not forbid reasonable classification. Anyone, if you can tell me about what is legislation and what is reasonable classification. See, once we are done with this theory part, I'll give you an example which will clear all these two concepts. However, I want, if anybody knows, then please let me know. What is class legislation and what is reasonable classification? Anybody?
Sir,
Reasonable
we
classification. I'll take this one. So as Article 14 or states that like should be treated or like anyone who is very much weak or vulnerable or some as compared to someone who is very financially stable. So in those cases, there could be a consideration that the person coming from a very vulnerable section can be afforded some sort of different treatment or unequal treatment just to bring him or her on equal footing with the person coming from a very financial or social stable background. So reasonable does allow some sort of preferential treatment or unequal treatment just to bring them to on equal level.
Yes, Akshay. Exactly. So basically, that Article 14 forbid class legislation. It doesn't forbid reasonable classification of person and transaction by the legislative for the purpose of achieving specific ends. Now, if classification has to reasonable, then it should fulfill two tests. I'm telling you those two tests, and if you are able to note down these points, then it will be helpful for you. Okay, you can use these points anywhere in your answers. So, first thing is that it should not be arbitrary, artificial, or evasive. What is the meaning of arbitrary? Anybody?
unreasonable,
You're saying unreasonable. Anyone else? Gargi is saying vague. Manusri is saying unfair. So we can take these literal meanings that it should not be vague, it should not be unfair, it should not be unreasonable, then it should not be artificial. Or what is the meaning of evasive?
unclear,
Yes. So if any law which that is evasive, arbitrary, and artificial, then it will not fall under the category of reasonable classification. It should be based on intelligible differentia. What is the meaning of intelligible differentia? Anyone? First test is that to be reasonable, any law has to, if any law has to be reasonable, then it should not be arbitrary, artificial, and evasive, but it should be based on intelligible differentia. So, if any one of you can tell me what is intelligible differentia based on some reason or understanding. Yes, Akshay, based on reasonable ground, based on intelligent inference. Yeah. So basically, intelligent differentia means that difference capable of being understood. If there is any difference, then you are able to understand the difference. That's it. All right. So this is intelligent differentia. Second thing, the second test says the differentia adopted as the basis of classification must have a rational or reasonable nexus with the object sought to be achieved by the statue in question. So these two things are which you can remember or which you can note down. That first, the first test of classification is that reasonable classification is that the law should not be arbitrary, artificial, and invasive. It should be based on intelligible differentia. And second thing, it says that differentia adopted as the basis of classification must have a rational or reasonable nexus with the object sought to be achieved by the statute in question. Now, what happens that Article 14 does not allow any kind of arbitrariness, but it ensure fairness and equality of treatment. So remember this thing. Once again, I'll tell you that Article 14 does not allow any kind of arbitrariness. It ensure fairness and equality of treatment. Now, I'm giving you a statement and I'll ask someone, particularly someone, that whether the statement is correct or incorrect. So if I say that Article 14 is the fountainhead of justice in our constitution, then this statement is correct or incorrect. And who is going to tell me? Monica.
Sir, I think answer will be yes.
Yes. So please remember this thing that Article 14 is the fountainhead of justice. So even this question will certainly come. It may be this year, maybe next year, or next 3, 4 years, but definitely they'll ask this thing. All right. Now what happened that whether a classification is reasonable or not, and one of the tests will be as to whether it is conducive to the functioning of the modern society or not. Are you understanding that if a law if a law which has to be reasonable, then it should be conducive to the functioning of the modern society. ऐसा नहीं होना चाहिए कि भाई कोई हेल्प मतलब इतना डिफिकल्ट हो, इतना वो हो कि कुछ हेल्पफुल ही नहीं हो रही है, कुछ फंक्शनिंग ही नहीं हो पा रही, और उल्टा हर चीज में जो है इट्स क्रिएटिंग बॉटल नेक्स. So it should not be like that only. All right. And one more thing I want to tell you that if you want to attract Article 14, it is necessary to show that the selection or differentiation is unreasonable or arbitrary. So remember this thing that if you are challenging any law, then you will have to show this thing that selection or differentiation is unreasonable. All right. So this is about this is about your reasonable classification. Now I'm going to discuss with you uh, class legislation. So I'll tell you something about class legislation. Just give me a second. But before that, I want to discuss with you a principle that is known as principle of initial presumption of validity. What is the meaning of this principle of initial presumption of validity? Anyone, if you can tell me, and you can speak, there's no problem. Anyone? So I'll tell you that there is always a presumption in favor of the constitutionality of a law, and the burden is upon him who attacks it to show that there has been a clear transgression of the constitutional principle. So I'll tell you a simple example. Say for example, government come up with XYZ law, and you say that this law is unconstitutional. But what does this principle says? This principle says that this enactment is constitutional. All right. However, you find it unconstitutional, so it is on you to prove that this is unconstitutional. Otherwise, it will be treated constitutional only, and the principle which will be used, that is principle of initial presumption of validity. So, initial presumption of validity of any law is that every law is constitutionally valid. Did you understand this thing?
Yes.
Yes, sir.
Now I'll talk to you about. So, are you able to understand what is reasonable classification?
Yes.
Yeah, and it
Yes.
is called doctrine of reasonable classification. Just remember those two tests, and you're good to go. Now I'll talk about class legislation. So, it is that which means an improper discrimination by conferring particular privilege upon a class of person arbitrarily selected. What happens in reasonable classification, that you make proper discrimination. Here, the discrimination is improper. Remember this thing. It makes improper discrimination, and by conferring particular privileges upon a class of person arbitrarily selected. Now I'll give you an example, and these two concepts will be very easy for you. So, how many of you are from commerce background? Anyone?
No, sir.
No one.
I was.
अच्छा, आपने कॉन्ट्रैक्ट एक्ट पढ़ा था?
क्या सर?
एक्चुअली क्या है कि देयर इज अ सेक्शन 11 of Contract Act, Indian Contract Act, and it's, आप अपना माइक बंद कर लो. Yes. So there's a section 11 of Indian Contract Act, and it says a person who have attained majority cannot but a person who have not attained majority cannot enter into a contract. So it is saying that if any person who is below 18 years, then that person cannot enter into any kind of contract. Okay, so just and you don't need to go into legal terms. Just understand what is contract. Okay, contract means that two people are agreeing on the same thing in the same sense. All right, for some sort of consideration, that is contract. So what happens that if you are below 18, then you can't make any contract. Fine. So now if we see that there are two categories. One is adult. Who are adults? And second category, minors. So it says the basis of classification is age, and which obviously has a relation to the capacity to enter into contract. So are you getting that if a person who is adult and who is above 18, so we assume that he has the capacity to enter into contract. He can understand each and everything about the contract. However, minor is unable to understand all the basic nitty-gritty of the contract. Therefore, the minor is not eligible to form a contract. However, an adult can do it. All right. So the what is the classification? The basis of classification is age, right? This much you have understood. Now,
Yes, sir.
uh, so uh, this is reasonable classification. Are you able to understand that why it's reasonable? The basis of classification is age, and they are saying those who are above 18, they are able to understand, they have better capacity to understand, and they can enter into contract because they can understand each and everything. However, minors are not able to do the same thing. So basis of classification is age. Now I'll tell you one more story. Say for example, there's a person called X. He belongs to a certain community, and this community thinks that it is the most intelligent community in the world. All right. Now what happens that to please these people, the government come up with a law and says those people who belong to X community, they they can, even they are below 18, they can form law. Sorry, they can form a contract. They can enter into a contract. However, except community X, no community can, no people below 18 from any community can enter into a contract. All right. So can you see that this legislation has been framed for a particular class, that they consider that this community is very intelligent. Okay, everyone is intelligent, they are able to understand each and everything, and therefore below 18 people can also form contract. But for other categories they think अरे इन लोगों से नहीं होगा, इनको समझ नहीं आएगा, इसलिए नहीं कर सकते हैं. सो आपने एक क्लास को अपीच करने के लिए, और इनको लगता है कि इस क्लास का जो है 5% वोट शेयर है, तो इसको लेने के लिए इन लोगों ने एक ऐसी पॉलिसी ला दी. अब आपको लगता है कि ये पॉलिसी फेयर है या अनफेयर है? व्हाट डू यू थिंक?
Unfair, sir.
It is unfair. Okay, okay. Yeah. And it's a improper discrimination. Now you are able to understand what is class legislation and what is reasonable classification. Perfect. Now I'll tell you two more concepts, and we are done with Article 14. So we'll talk about the new concept of equality. So the traditional concept of equality is based on the doctrine of classification. The new concept is based on the doctrine of arbitrariness. Now, what is this doctrine of arbitrariness? Anyone? Anyone, if you can tell me about doctrine of arbitrariness. It is nothing but any state action that is violative of Article 14. It is arbitrary. All right. It's a very simple thing, that any state action that is violative of Article 14, it will be considered arbitrary, and it is called doctrine of arbitrariness. That's it. So we are done with Article 14. Now, if any of you have any question with regard to Article 12, 13 and 14, you can ask me. Otherwise, we'll start with presentation part.